Thank you everyone for joining. Following today's presentation, we will share the materials and a link to view the recording. And without further ado, I would like to introduce everyone to our President and CEO, Ms. Angela Franco.
Well, good morning, everybody. Thank you so much for joining our Employer Advocacy Program seminar this morning. I'm Angela Franco. I'm the President and CEO. I've been, for the ones that haven't met me, I started as interim in July 2020, and I was named full-time president or permanent president on March 8th. So happy to be here with all of you. As you know, the Chamber of Commerce has been around for 83 years. We're the oldest and largest business organization. And right now we are really putting a lot of effort in helping our businesses move forward from the pandemic. I've been in the business community forever. I'm extremely passionate about, helping people and helping businesses. So again, thank you for joining us this morning. As part of the partnership with the DC Department of Employment Services, the Chamber is committed to providing local employers with quarterly employment law trainings, as many regulatory and labor policies that can impact our members. In addition to seminars like the one today, we offer opportunities for businesses to grow and do business globally. And as part of this, we're also hosting a virtual trade mission on June 29th and 30th to Ireland, if anybody's interested. We just did one to Greece, and we're taking a group of businesses to the cybersecurity conference in Greece in the month of July. We're also a grantee partner for SMEs that want to increase their presence in international markets, and exporting contributes to economic growth. And we are also looking into opportunities to help our small businesses grow in different ways, like certification and others. But for today, we are going to be focusing on the training, the regulatory and labor policies that can impact you. It is very important, especially in this environment that we're in. All these policies are changing, are constantly changing, and it was our commitment to bring firsthand information to all of you. I want to thank our presenters this morning from our member company, Baker McKenzie. Thank you so much for helping us this morning. And now I would like to turn it over to Ryan Jones, our legal counsel for the DC Chamber Employer Advocacy Program, for brief remarks about the EAP services. Ryan?
Thank you, Angela, and congratulations again on your new position with the Chamber as CEO and President. Good morning, everyone. I hope you are enjoying this Monday. We have an exciting and informative presentation by Baker McKenzie from Krissy Katzenstein, Dee Oluwude, and Autumn Sharp. As Angela mentioned, it's critical to having this information as we re-enter the employment atmosphere and what that will look like as things move forward. This is an added benefit for any lawyers that are out there. You can get credit for a CLE, which is important when maintaining your bar license in your respective jurisdiction. I'm Ryan Jones. As Angela Franco mentioned, I am the Director and Legal Counsel for the Employer Advocacy Program, sponsored by the DC Chamber of Commerce in connection with the Department of Employee Services. What we do here with the EAP program is we represent employers when they need representation before the Office of Administrative Hearings with matters of unemployment claims. So when there's a determination made by DOES regarding an unemployment matter or claim by an employee, we step in, we represent you, and before the Office of Administrative Hearings, as well as through the Court of Appeals if there is an appeal that is taken and there is merits to allow that. I would represent you through that process. So if an employee needs to be terminated for gross misconduct, there's some sort of issue of lateness, abuse, I step in and argue those merits. If there's an issue of a quit, a voluntary quit, and we would step in and represent you on that as well, among many other issues. So please don't hesitate to call us if you are facing an appeal before the Office of Administrative Hearings or a UI claim. There are many, many claims happening right now of varying natures given the climate of our economy. So having an attorney represent you helps with the administration of any of your matters. So please don't hesitate to reach out. Again, we have Baker McKenzie here to present on the re-entry to the workplace and the burgeoning issues confronting a new working landscape. So I'm excited to introduce first Krissy Katzenstein for Baker McKenzie.
All right, great. Thanks, Ryan. And thanks to the Chambers Group for inviting us to present today. We have 4 main topics that we're going to cover for you, and the deck should pop up here in just a minute. But we'll start with remote work setups and what that's going to look like potentially in a post-COVID environment. We will then transition to off-duty conduct and things to be thinking about as that line becomes a little bit blurred. And COVID litigation, and then wrap up lastly with the new changes in DC law as they relate to non-compete agreements. So as we go through, we would encourage everybody to ask questions. There's the chat feature. If you want to put the questions down there, please feel free. I think people may be able to come off of mute as well, so don't hesitate to do that, and really do want this to be as interactive as possible and be sure that we're answering any questions you may have. So with that, I will turn to the first topic, which is the continuing remote work policies. So what we're seeing here, there's a lot of surveys that are happening by third-party groups and employers themselves reaching out to their employees and saying, what do you want the post-COVID work environment to look like? And we see here, BCG did a survey, 89% of employees who are remote said that they expect to remain remote in some capacity. There seems to be evidence that employees really would like a hybrid environment, meaning they'll be remote for a couple of days the week, in the office for a few other days. There's even been some surveys out there where I think it was 58% of employees said that they would rather quit than have to return to the office full time. So I think the one thing that is becoming more and more clear, if it's not already, is that employees like the flexibility that comes with remote work to the extent that they can be remote, and hope that some piece of remote work persists even after we're able to go back to the office more regularly. And with that, it's interesting because I think everybody rushed very quickly as the pandemic was hitting to transition people to remote work. So there wasn't a lot of time to think about what is the best way to do it, what makes the most sense for our organization. So even though pre-COVID we were seeing that uptick in remote work, we're sort of squarely in that world now and thinking about what should remote work look like for our organization. And traditionally, we had sort of what we all thought, if I was a remote employee, I would work from home and be telecommuting. But I think there's now variations is what we're seeing as employers are thinking about what is this going to look like going forward, where there's certainly going to be setups that are fully remote, as we traditionally have thought of remote work, some that are temporary. So employers are considering shorter periods to accommodate what might be short-term employee needs. And then we see this hybrid concept that's really, I think, becoming more and more common. At least that's what we're seeing with a lot of clients, where there's some number of days you're expected to be in office and then some number of days where you're expected to work from home. And that's the one that I think is going to be probably more and more common as we're moving out of this COVID environment. So with that, there's a lot of questions that we're seeing clients face around what should we be thinking about and how do we really implement a more long-term remote work policy. So the first issue is really thinking about what it means to be remote for your workforce. Are you going to allow permanent versus temporary remote work setups? Is this going to be, are there going to be geographic restrictions? So certain places where employees can't be situated in working, or for example, a perimeter in which you can work within 50 miles of any of our locations. There's a lot to think through, and what impacts that in some respects are all of the other considerations. So what are the tax implications? What are the implications to privacy issues? What are the implications on just your general corporate structure? And do you already do business in that particular location? So the first step is really defining how most effectively you can have a remote workforce and where they should be situating, how long that arrangement should persist. And then it's those guardrails, which I alluded to, of are there going to be certain places where we think we prefer not to have employees situated, or where we might restrict the number of employees. So when thinking about a lot of the employment laws, oftentimes there's a trigger level. If you have 25 employees in this state, you become subject to some additional restrictions. So do you want to be thinking about those sorts of issues and saying, okay, maybe we won't hit 25 in California because we don't want to be subject to X, Y, and Z. There's also the issue of just, do you already have a legal presence in that particular state? And if the answer is no, what are the ramifications, both from an employment perspective, but also from a broader corporate perspective of allowing employees to do work in that particular location? So it's really important on the front end to think through those sorts of issues, broader than just the employment impact, but what are the tax implications, the corporate implications, and all of these other issues that all of a sudden you're doing business in a new place, potentially, and what does that mean? The other thing that remains important, and this is something we saw pre-COVID and should persist post-COVID as well, is having an application process. So being very clear when employees are applying about what are the jobs that are eligible, what are the locations that are eligible, are there justifications that are going to be required? So are we still going to ask for some sort of explanation for why remote work is needed? Or is it going to be that the world we're in now, everybody's able to work remotely unless they're in a position where that's not allowable? And so thinking through those sorts of issues is really important as well. And that's primarily to ensure consistent treatment on the front end. So the potential problem is that you might have some managers saying yes for employee X, another manager says no for employee Y, even though those two employees are doing similar jobs. So having that consistent framework is critical at the outset so that you don't have any issues about potential differing treatment between managers or between employees who otherwise look pretty similar. The next item to be thinking through is really around your other policies. And this is one where I think it's probably the most complicated to really look at holistically. What are the employment policies we have and how are they impacted by remote work? So salary is one that a lot of our clients are struggling with. And what does it mean if you had an employee who was based in DC, who's now decided to relocate to Iowa? And what does that mean for their salary? Are you going to cut salary because they're now in a very different cost of living location? Are we going to let their salary persist, but then not up the salary or lock it in essentially over time to try to catch them up to what's appropriate for their location? So it's absolutely one in terms of compensation that is being turned a little bit on its head as we have employees who are working in very different locations from what we saw pre-COVID. You also need to be thinking about things like equipment. How are we going to ensure that employees have adequate equipment? What are the guidelines? What are the usage standards for when they're working remotely and not in the office? Expenses is a huge one as well. So we obviously have certain locations where expense reimbursement is required, but that's certainly not every place. But if we're going to have a consistent policy across employees, or maybe we're going to have a localized policy, but thinking through what are going to be reimbursable expenses for those who are working from home and what expenses will not be reimbursable, and spelling that out at the outset so employees know. There's also the issue of overtime and meal breaks, which is something that I think a lot of employers have worked through as we've worked through this COVID period, but those issues will certainly remain, particularly if employees are going to be permitted to work anywhere. Being sure that you know those local laws and have procedures and mechanisms for ensuring compliance is very important as well. And then travel policies. So what is going to be acceptable travel for those working remotely? What is not acceptable? And spelling that out at the outset as well is really important as you're working through this. What does our new policy look like? So really it's sort of thinking about what do we want remote work to be? How are we going to explain that to employees? And then what are the implications for all of the other employment policies we have, and ensuring that we're spelling that out at the outset. And critical through all of this is making sure employees are aware that working from home remains a privilege. So it's not just an absolute baseline now, but it's something that there need to be mechanisms built in as well that will explain if there's performance issues, if there's productivity issues, that the employee may be expected to recommence in office employment, or rather than being hybrid, be in office every day. And those should be set out at the beginning as well. And it ties back to what's going to be permissible too. So if we are going to let our employees work anywhere in the US, calling them back to be in office 5 days a week is probably not realistic. So what are the other mechanisms you're going to be having in place that will ensure that, okay, if we have a performance issue, how are we going to manage that? if saying come back into the office really isn't an option. So it's important, again, to really think that through at the outset so that there can be repercussions or can be increased monitoring if there is some sort of productivity or performance issue. And this then goes to sort of the individualized remote work agreements. So again, making sure employees are clear on what the standards are from the very beginning. So here's what the comp will be, here's what your hours will be, here's what's expected from a productivity perspective, and here's the repercussions if you don't meet that expectation. And this is one too where I think it's important to note we have a lot of clients who are toying with the idea of using AI to monitor productivity. So whether that means how many times your mouse is clicking an hour, how many times your computer is locked, or more advanced ways of saying, are you actually making progress in terms of what documents you're working on, for example. And so as employers begin contemplating those things, I think it's important too in that initial agreement to be explicit that employees will be monitored technologically, and that may come in the form of productivity monitoring or any number of things so that you have employees clearly on notice from a privacy perspective that there will be monitoring that goes on, and that will be one mechanism for holding them accountable for the work that's being done. So then determining the statutory and legal obligations, we touched on this, but you're going, if you have employees working in different states, you'll have obviously different leave of absence laws, different paid time off laws, different standards around meal breaks, overtime, all of those sorts of issues. So being sure you know where your employees are and what those applicable standards are is very, very important. And likewise, it's also, as we touched on, important to know what are the implications from a tax perspective, from a corporate perspective, IP, all of these other issues that play in. So it is very critical to be sure that as you're working through these issues, that broader legal framework is still front of mind. And lastly, I think that, it's really planning for the long term. So this is not sort of getting through the COVID period anymore. We think we're largely turning that quarter, thinking about return to work in some ways. So it's what's going to work for the organization long term, as we have now, had a year and a half almost of remote work, trying to get people back in some cases, but what really makes the most sense to ensure that we have a productive workforce.
Krissy, I don't mean to interrupt, but I just actually have a question that maybe everyone else might also be interested in hearing. So what are you actually seeing in terms of employers allowing employees back into the office or not, to continue to work from home or not allowing it? And what are some of the top concerns that they're voicing?
Yeah, it's really an interesting dichotomy that we're seeing. I think there's largely two camps, the ones who are preparing for what will largely be a continued remote workforce, and those who are very actively trying to get their employees back into the office and incenting that type of behavior. And I think for the employees who are trying to get, or the employers who are trying to get their workforce back into the office, there really is a sense that we are a more productive, a more collaborative, a more team-oriented workforce when we're all in the same location, when we're able to talk to each other outside of the Zoom context, which of course Zoom has been fabulous, but I think there's a sense that there's a little bit something missing still from being able to run down and knock on somebody's door. So it's really about that, I think, team and collaboration and culture that those employers are concerned about. The employers who are going full remote have all of the concerns that we just talked through that are front of their mind in terms of how are we actually going to be able to do this on a day-to-day basis? How are we going to make sure employees are working? How are we going to make sure people are being paid fairly when they're working all over the United States with very disparate costs of living? So that those are a lot of the issues that we're seeing right now popping up.
Well, thanks. Absolutely. I think we're all a little eager to be face-to-face a little bit now.
Yeah. I think even those, I think that's what makes the hybrid approach so appealing to employees, is I think employees like having some of that interaction, but they also like not commuting, not having to necessarily, get dressed, get out the door, get to work every single day. So it gives the ability to have sort of the best of both worlds. And one other thing that we are just sort of keeping front of mind as employers are becoming more and more remote or offering it, at least as an option, is ensuring that it doesn't result in any sort of disparate treatment or disparate impact for those employees who are working remotely. So making sure that the opportunities are equal and that inadvertently we don't see slippage in terms of who gets promoted, the performance ratings employees are getting, or if you have a reduction in force, for example, who's getting reduced because of the fact that they're remote. There's some concern that just the lack of physical presence could result in that, whether intentionally or inadvertently, managers not treating employees who are in office and outside of office in the exact same way. So here, I think what we'll see going forward is more monitoring around this in terms of collecting data for those who are remote versus those who are in the office, and running adverse impact analyses to say, do we see a difference in promotion rates, performance ratings, who's being let go as part of restructurings, and really making sure that that remote piece isn't factoring in. And the other is just having training for managers so that they're also aware that whether somebody's in the office or not isn't a meaningful consideration for the quality of work that they're producing, or whether or not they should be eligible for that advancement opportunity, and being sure that everybody's just aware of what impact being a remote employee should have on somebody's employment. So I will pause there. If there's any questions that we have from the group, please feel free to chime in, and then I'll turn it over to Autumn. All right, I think it's all you, Autumn.
Yeah, great, thanks. Absolutely, and we do definitely encourage folks to, if you can and you want to ask a question, turn off mute or send us a question in chat. So the next topic we're going to cover is off-duty conduct issues. I think for the last year and a half, it's been one of the most interesting political climates between the presidential election and Black Lives Matter, and just how people feel about COVID-19 safety precautions. Do you mask? Do you not? Are you going to be vaccinated? Are you not? And so we've got a lot of, I think, generally a lot of emotion now in the workplace, outside of the workplace. And whenever you bring politics into the workplace, you definitely can count on there being some disruption. And so one of the things we want to do is talk about what employers can and can't do with regard to off-duty conduct by employees. And then we'll also circle back and talk a little bit about on-duty conduct as well. So first, let's start with just some general considerations about what employers can and can't do. So employers can prohibit employees from representing that they're speaking on behalf of the company, or that they have the employer's blessing for their particular political activity. And company policy can require that social media accounts don't identify the person as being employed by the company, and that the employee expressly state that the views expressed are their own and not those of anyone else. And company policy can also require that where an individual is identifiable by colleagues or business contacts on, for instance, Facebook or Twitter, that they must respect the company's values, that they don't contain racist, sexist, or homophobic material, that they don't suggest that they're intolerant of a certain category of people, that they don't use disrespectful language that could, hurt their colleagues' feelings. So there are some controls in place that companies can use just to make sure that they can maintain a respectful workplace, even when you're talking about off-duty conduct. So how do you handle it if there's a violation by an employee? So employers should consider an employee violation in these sorts of cases, for instance, a violation of a social media policy or of a respect policy, on a case-by-case basis. And so it is important to have a specific review process in place to make sure that everyone is treated fairly in that process. But it really is a case-by-case basis, because generally you're going to have, very individualized situations that you're going to want to handle. So it's important to take into account exactly what was said and the circumstances surrounding what was said. You don't want to just kind of make this a generalized consideration, because again, every one of these situations is something that is very individualized, could deal with different political viewpoints, and could impact and will impact people or colleagues differently. So let's talk about what you could generally most likely discipline or dismiss for. So that's when we're talking about posts that include threats or vulgar speech, that's obviously something that you could discipline for. or posts that even could damage the employer's business reputation, or suggest an intolerance towards some coworkers. So for instance, if you've got an employee that's sharing racist posts, or an employee that is sharing posts that are dismissive of people who are transgender, those sorts of posts are ones that you don't have to put the business and other colleagues in a bad situation to allow employees to continue to make posts along those lines, and also any unlawful or illegal activity. But if none of those have occurred, it's going to be a little more difficult to take action. And again, as I said before, you really have to make sure that you're applying the same analysis to all employees who might express their political views. You don't want to get into a situation where you're being accused of disparate treatment. And so if you have an employee who has violated a policy, how do you communicate with that employee? What are the next steps? What should you do? So these, there are plenty of factors that you'll have to look at that will be relevant in considering the best way to handle the situation. So you're going to want to look at how the employee expressed their views. So is it something that happened to be in private, and then perhaps the coworker brought it to HR's attention, or is it blasted all over Twitter and Facebook? How the company became aware of the employee's views. Again, was it something that was public and everybody in the world knows about it, or was something that was a little more private? Did it seem like the employee was really trying to put the company in a negative light, or was it just kind of a one-off conversation that someone had a concern about? Was anyone else employed by the company aware of the expression? Again, that's going to kind of really in this day and age be a lot of, was it on social media or was it not? And also the position the employee holds. If the employee is in a high leadership position, then you might want to, really consider how that is going to affect other colleagues. And that will be most likely kind of treated a little bit differently than maybe somebody who's not in a leadership position, or somebody who is not your high level employee. And then you also want to look at the jurisdiction where the employee works. If you're a multi-jurisdictional company, you have employees all over the country, then the analysis is going to be a little bit different, because certain jurisdictions do prohibit employers from regulating lawful off-duty conduct and expression. So you're going to have to take that into consideration as well. And so once we've looked at all of those factors, you'll want to discuss with the employee the company's values and how those values are carried out through the company's policies and procedures. And the reason this is important is because you might have an employee who intentionally, made a political expression that it seemed like it was intended to harm the company or colleagues, but also there could be some employees who really just for whatever reason, the company's values and how their political expression has impacted maybe the company value system is not really top of mind. So what you're trying to do here is make sure that you can maintain your respectful, value-driven workplace. And so you don't want to overkill the situation, but, discuss with the employee, like, here's what you did and here's why it is, not in line with company values, and really have a conversation, because it could just be a situation where you need to kind of remind the employee of what they did and why it was not in line with the company values. And then also, inform the employee that you're aware of their political views and that they're contrary to company policy, the expression of political views. But again, you want to be careful depending on how the company was made aware of those views. Also, it's important to remind the employee that they're free to have their own views, and the company does encourage diverse thoughts and opinion, whether it's about politics or anything else. But the key here is when employee is out the workplace or performing work for the employer on behalf, performing work on behalf of the company, engaging with clients or customers, and around other colleagues, that the employee is expected to really pay attention and follow company policy and viewpoints. And then it's important to make it clear that the employer is not regulating the company's, not regulating the employee's off-duty conduct, because it's really important to make sure that the employee understands that off-duty, that they are free to express their viewpoints, but at the same time, within that limit of making sure that they're not doing anything that's pointedly detrimental to the company if it's out in public. And that the employer wants to make sure that the company's policies and values are being adhered to when the employee is acting on behalf of the company.
And Autumn, just a quick question for you around, you mentioned earlier that it's really important to look at each potential violation on a case-by-case basis, but how are employers, or how best can they mitigate against potential claims of adverse or differing treatment from one employee to the next if we're really looking at this individually?
No, absolutely. I think that's really where it's key to have a policy and a procedure in place that is utilized in the same way every time. So again, your situation is going to be different, but it's really key to follow that policy. And obviously with anything along these lines, you want to make sure you're documenting every step you take. So that if there's any question about any kind of adverse treatment, they interrogated me and they don't usually interrogate other people, or they took these steps and that's not the norm. You just want to make sure that it's very well documented, that HR is involved in everything. And just again, to make sure that the policy and the procedures that are part of that policy are followed through to a T with each and every individual that finds himself in this situation. So let's talk a little bit about social media policies and on-duty conduct. So generally, employers have more leeway to monitor social media activity on the employer's systems when the monitoring is pursuant to the employer's a written policy. So it's really important to have a written social media policy. And that policy should be clear that employees are not entitled to make statements about the company that are really offensive or that publicly disparage the company or otherwise violate the company's code of conduct. Also, the policy should reiterate the company's discrimination and harassment policies. That's really important. And it's really important to include, again, kind of just to bring the employee back to the importance of the anti-discrimination and anti-harassment policies. And also emphasize that discrimination and harassment on social media are prohibited. So racist slurs, sexist remarks, those sorts of derogatory comments are prohibited. Those subject the employer to liability. So it's really important to make sure that employees understand that, that is prohibited conduct. And it's also important to remind employees that those who are found to use those remarks could be disciplined up to and including termination. And employers should always apply social media policies and other policies in a consistent and non-discriminatory manner, which we just kind of discussed. It's really important to follow the policies and how they apply to each employee to a T, even when taking into consideration the differences in each situation. There are some restrictions on employers' ability to monitor employees and discipline them for their social media use. So employers should be cautious before accessing an employee's social media account without their authorization or coercing employees to turn over information that's posted on social media. So there are some different specific laws. For instance, in more than 24 states, employers are prohibited from requesting social media usernames and passwords from employees. Most of these states actually allow employers to request the information to access an employer-owned device or account. So this is where you kind of have to determine whether or not you want to, include a BYOD policy, or whether you just want to provide all your employees with employer-owned devices. But also there's acts such as the Stored Communications Act, which protects the privacy of wire, oral, and electronic forms of communications, which includes telephone, email, and internet communications from unauthorized access. So those are all things that you want to consider. And then there are the potential issues under the NLRA, but free speech guarantees may also apply, and that depends on applicable state and local law, jurisdictional law. There are some federal, state, and state statutes that also regulate an employer's ability to monitor employee social media activity. So now we're going to turn to on-duty conduct and kind of what the guidelines are there. So on duty, there's no general right to free speech in the private sector workplace. and private sector employers are generally free to prohibit and discipline employees for discussing politics at work. So, this is kind of where this topic arose, because we've got a lot of private sector employers that are dealing with this sort of, and it's been a year and a half. So from the time of the presidential election all the way through, we've got the Black Lives Matter movement with COVID-19 and health and safety issues and differing opinions on that. It's really just, there's been a lot of activity. There are some ways to limit disruptive political expression in the on-duty workplace. So employers can establish office policies and hold training sessions, and the training sessions are important. The policies in place, that's wonderful, but you really want to make sure that your employees understand not only policies, but the reasons behind them. And so the training sessions on showing respect to coworkers, I think, is a really great way to kind of bring everyone together and make everyone understand that we might have different political viewpoints, but at the same time, we are all in the same workspace, whether it be virtual or real, and we need to get along. Kind of just what you learn in kindergarten, basically. You don't want to focus specifically on politics or social movements, because that can actually have the effect of fueling conflict. So instead, just try to strive for inclusiveness and try to make everyone understand that if we can we may not all agree, but if we can actually get along, then we'll all be much more productive. And also, just have a more inclusive, more pleasant workplace. Dress code policies is a big one. So you want to ensure that those do prohibit employees from displaying political expression. You don't want political buttons or logos or other political speech. And that includes prohibiting items displaying support for a political party or cause. And you want to make sure that's enforced in a non-discriminatory manner. So make sure that that is across the board. Adopt and enforce non-discriminatory rules prohibiting non-work related political activities in the workplace. Again, we want to be non-discriminatory with this. It's across the board. But remember that political activities with a sufficient connection to employment related issues can be protected by the National Labor Relations Act or applicable state law. So you want to make sure that you're not violating that when you're with your policy. So let's talk about that a little bit about the NLRA. Non-supervisory employees do have a right to engage in protected concerted activity under the NLRA, which can allow them to take action such as talking with coworkers about wages, benefits, or other working conditions. They can participate in a concerted refusal to work in unsafe conditions, and they can join with coworkers to talk directly to management or to talk to a government agency or the media about problems in the workplace. So you also want to create and implement and enforce uniform non-solicitation policies during working times and working areas. Again, uniform, non-discriminatory, make sure it applies across the board. So you can do things like limit the use of company equipment or resources. Have a policy that does not allow work computers, photocopiers, email or bulletin boards for non-work related purposes. And then it's also really important to reiterate the company's zero tolerance policy for discrimination, harassment, and retaliation in the workplace. So again, tell employees you're entitled to your beliefs, right? That's important. And you're entitled to discuss them privately with others, but you're not entitled to discriminate or harass coworkers, and you're not entitled to use company equipment to do that. So those are some ways to make sure that employees, have some freedom to express themselves in the political world, but realm without bringing it into the workplace and making a harassment or a harassing situation or a discriminatory situation for their coworkers. So now I'll read the CLE code, and you can actually see it there. It's CD062121. And before I turn it back over to Krissy, if anyone has any questions, feel free to let me know.
Thanks so much, everyone. Feel free to include your questions in the chat, or if you can virtually raise your hand for any questions to either Autumn or Krissy.
All right, great. So I think that brings us to COVID litigation and what we're seeing, what we're expecting. So we are continuing to see an uptick in COVID related cases, and I don't think that's either much of a surprise or something that's likely to end in the near future. The expectation is that we will continue to see an increase in these types of cases, and probably even more so as we have some employees going back into the office. But in terms of the types of cases that we're seeing, I thought it would be helpful to just run through the types of cases. And the first is around accommodations and leaves of absence. So employees who are seeking leaves to care for others, to care for their own condition, and either experiencing some sort of interference with the leave of absence or claiming that they've been retaliated against for seeking or for taking that leave of absence. So those are still claims that we're seeing, still claims that we're expecting to see on a go-forward basis. Discrimination claims, so we are still very much seeing traditional race, gender, sex discrimination types of cases, both disparate treatment, disparate impact, sex harassment as well. But I think what is really where we're experiencing the uptick is around ADA claims and failure to accommodate claims. So there's certainly a number of claims that are being made by employees who claim that they either need to work remotely as an accommodation or need some sort of special modification to the work environment in order to feel that they can safely work in that environment. And again, as people are going back into the office and we're seeing some people who are vaccinated, some people who are not, it's likely that we will continue to see a large number of those reasonable accommodation claims. Health and safety has really been where the bulk of the claims to date have come from. And that's with employees who fear going into the workplace for some reason, making claims, or employees who have been required to work throughout COVID, making claims that the conditions aren't safe or that the employer isn't providing adequate safety protocols in that workplace. And that's one where we've seen a huge number of cases, some of which have been very well publicized in the news. But also what flows from these types of cases are retaliation cases. So, and frankly, wrongful or constructive discharge cases where employees raise the issue around safety and have claimed that some sort of adverse employment action has been taken as a result of that claim, or that they've essentially been forced out of the workplace for raising the issue. So still a good number of cases in that space. Privacy is another area where we've seen cases, we'll likely see more, and this really relates to what we're doing with the information around testing, for example. If we're requiring testing, how is that information being stored? If we're going to be requiring proof of vaccination, how are we going to be storing that information? What safety and privacy protocols will be in place? So this is when it's important to keep it in the backs of our minds as we have people going back, because it's also one that's susceptible to class action challenge likely. So if there isn't a strong protocol in place for what we're doing with people's private medical information in particular, that's certainly a ripe area for challenge. Remote work is also an area where, as we talked about, we're likely to see some claims on a go-forward basis.
Krissy, I'm so sorry. Before we move on to other COVID litigation trends, I have a question. So there are some jurisdictions, it seemed to start with Santa Clara County, and then in California, and now I know the state of California is allowing this under OSHA. Some jurisdictions are allowing employees to self-certify that they're fully vaccinated to go mask-free. And this goes a little bit back to the health and safety. Instead of actually providing, documentation, their vaccine card or something along those lines. What, in your opinion, are the upsides or downsides of this method?
Yep, absolutely. And I think this actually, it goes with the health and safety. It also goes with the privacy issue as well, because a lot of our clients who are saying we're going to do a self-certification method, it's really to avoid a lot of the privacy issues, the data security issues. That is a vaccination card, a medical record issue. And that's really why the self-certification is so appealing. You can ask your employees yes or no, they say yes or no, and then you don't have to worry about what are we going to do with a copy of this vaccine card. But for those, on the flip side, the real concern, I think, is one around, are we getting honest answers? So are we able to trust that what is being reported is accurate of whether an employee is or is not vaccinated? And that really becomes important, because for some employers, it's going to impact whether you need to be wearing a mask, whether you can go to the cafeteria, whether you can go to the gym, whether you're on certain restricted areas for vaccinated versus unvaccinated. We're seeing a lot of creative ways of trying to bring comfort to employees who are vaccinated and also accommodate those who are not. And so that sort of, are we getting accurate data piece is important for those sorts of issues. And I think that's really a concern for a lot of employers in terms of whether self-certification is enough.
That's great. Thank you.
I have a question, Krissy.
Sure.
In the district and the surrounding areas, are employers permitted to require that their workers that are working in the office be vaccinated?
Yes, so within the DC metro area, so Maryland, Virginia as well, the federally, the EEOC says, yes, we can ask and you can mandate vaccination for your employees. State laws are really spotty on this, but within the DMV currently, employers are still able to ask and still able to ask for evidence of vaccination. There's pending legislation. It's been tabled in both Maryland and in Virginia. The Maryland legislation would say that you can't terminate somebody because of their refusal to become vaccinated. And the Virginia legislation would say you can't discriminate against somebody in any capacity because of their refusal. So that's out there and could factor into how we treat this question. But currently employers are able to ask and say, if you want to be back in our office, we're going to require that you show proof of vaccination.
Hi, I have a question.
Sure.
So as far as work hours and making sure that everyone is, employers are complying with the amount of work hours within the work period, how are we going to make sure that employers comply, knowing that with remote access to the office, people bleed into some, over 40 hours, and how are we addressing overtime?
Yeah, I think that this is a place where there's going to probably need to be even further technological advancements, because it is one where it becomes so critical with your non-exempt population, and having a way to, you turn on your computer in the morning, you clock in essentially at that point in time, we see you exit out of it as essentially a clock out for your lunch break or for your rest break during the course of the day. And then at the end of the day, that it really does shut down unless there has been, some exception granted for overtime, or depending on the policy of the employer, employees are able to work overtime. But it also comes down to training. So employees need to know that whatever time that they're working needs to be clocked. They need to be reporting it. Even if it's overtime and they don't have authorization, it's still the employer's obligation to pay that time. So employees need to know, and that just needs to be reiterated over and over again, so that if you do end up in litigation around this type of issue, you'll have lots of documentation to say, employees know the policy, this is our policy, we pay for all the time that's worked. But I do think we're also going to need to see some technology come in here as well to be sure that we have good records, because that's what becomes more challenging, right? If you're clocking in and out, we have the time card records, but we need some equivalent of that for remote workforce. And I think we'll continue to see advancements here for how you do that well, to make sure that we have the most accurate time for our employees. But you're absolutely right. I think we've all experienced sort of COVID time is a different dynamic than usual time, in the sense that, an 8-hour day becomes 10 pretty quickly.
And as a follow-up question, because of what you've given us here, if there's technology advancements, can you foresee privacy issues? And what would you imagine employers should be safeguarding themselves against for access to, an employee's private information, things of that nature, when people are clocking in and clocking out, or not clocking in appropriately?
Yeah, and this is one where, again, it becomes critical, Autumn alluded to this, of having that policy at the front end that says you have no expectation of privacy when you're working on a company laptop. That means your personal emails, it means the websites you're looking at, it means the time you're coming in and out. And we will be affirmatively monitoring that. So be on notice that the times that you will be working, the way, what you will be working on, all of those things are subject to monitoring by the company. So I think it will be a revisit of those language we likely already have about privacy in the workplace, to just make sure that it encapsulates what we're seeing with respect to remote workers as well. But a lot of it is a notice issue, to be sure that employees aren't expecting that there is privacy with respect to what they're doing on their work computers or during work time.
Awesome, thank you.
All right, so in terms of additional litigation trends that we're seeing, wage and hour claims have also been huge, and I think will continue to be huge. Some issues here are around misclassification. So if you have outside sales employees who've been sitting home and not working in the field for the last year and a half, have different duties, different hours, does that change their classification? So we'll likely see additional challenges in that regard. But I think the bigger challenge that we've seen lately is around the COVID protocols when you come into the office. So what do you need to do from a timing perspective before you can actually start work? Are you doing temperature checks, symptom checks, filling out questionnaires? And is that compensable time? That's an issue where we've already seen class cases popping up. And I think of it as similar to the donning and doffing cases that we've seen over time in terms of putting on your work equipment each morning and taking it off. And I think that analysis will likely be analogized to this situation going forward to say, is this compensable time or is it not? But it's certainly an area where we're likely to see litigation and already have seen a fair amount. The warrant cases are popping up now. So obviously at the start of COVID, a lot of employers had to do reductions. And now what that has spurred is a number of warrant cases and actually some challenges to COBRA. So challenges that employers didn't provide the correct COBRA notifications and documentation at the time of separation. Hopefully these cases are actually on the downslope as what we're seeing is a huge ramp up in hiring at this point, but they still are lingering out there for everybody to be aware of. Employee defection, duty of loyalty, trade secrets, another area where just being remote is a big uptick in these types of cases. So initially it was sort of everybody, as I said, was rushed to get everybody remote, but not being able to have the luxury of time to think through how are we going to protect our trade secrets? How are we going to make sure that things are not being misappropriated? And so we actually have cases cropping up now where employees have misused company property and it's the employer bringing those types of cases. But this is, again, just an area where it's really important to think through how do we handle this? How do we handle security, confidentiality in a remote world? And the last topic that we're seeing cases likely to continue is around vaccinations. So this goes to Erica's question earlier of can an employer require vaccinations? And we've seen several, particularly healthcare hospital providers that have said, if you're going to be working, you need to be vaccinated. And what we've seen today are challenges, particularly because all of the vaccinations were initially for emergency use authorization, which meant that they weren't fully approved by the FDA. So the theory coming forward was, without that full FDA approval, you shouldn't force me to be vaccinated because we don't actually know the safety and efficacy of this vaccine. What we've seen so far from courts is a rejection of that argument and the notion that for a hospital, for example, there was a case the other day where the court said the public safety issue of having unvaccinated employees caring for ill people is far more important than the personal choice of whether or not to be vaccinated. And I think overall, as COVID is still a very real threat to the country and to the world, there'll be that balancing of what is the safety to the overall public versus the individual choice to be vaccinated, with the scale falling in favor of public safety, so long as we're in this world where it is, a pretty strict guidelines around what we can and cannot be doing, social distancing, all of those sorts of things. All of that said, though, as I said, EEOC says you can ask and you can mandate vaccines. So subject to state law, that hopefully will continue as well. And we touched on this a bit earlier, but again, just EEOC has said, yep, you can require vaccines and you can ask about it. We are seeing a lot of state laws that have said, no, you can't ask, or have created some other hurdles to being able to ask about vaccination status. So what we're seeing from most clients at this point is that many companies are strongly encouraging employees to become vaccinated. Some are incenting vaccinations, but none of them are going so far as to require it outside of the healthcare provider / hospital context, where we have seen a lot of that required obligation to be vaccinated. So that's sort of the trend at this point for most non-medical providers, is encouraging strongly, but not requiring vaccinations. And again, this raises the question around proof of vaccination, which we touched on self-certification earlier, which is just an employee simply representing one way or the other whether they've been vaccinated. which is certainly one way to go about it. And if we're doing a self-certification or if we're requesting proof, a good reminder for everybody is just to be sure to have that GINA safe harbor language in there. So be clear that you're not asking for genetic information. Communicate with employees about the purpose of the request, and also be clear with employees that there will be accommodations if you have a religious belief or if you have a disability that precludes vaccination. So those are, overarching principles in terms of accommodation that whether you're requiring it or strongly encouraging it, you need to be sure that the process also provides accommodations for those who are disabled or for those who have sincerely held religious beliefs that preclude vaccination. All right, so this then raises the question that we've been getting a lot around face masks. So are masks still required as we're becoming more and more vaccinated? And in light of the fact that the CDC has said that if you are vaccinated, fully vaccinated 2 weeks out of your vaccine, you are free to go without a mask in most situations, provided you maintain social distancing. And we certainly have some employers who are implementing that in the workplace. So if you are fully vaccinated, you're mask free. If you are not vaccinated or haven't disclosed your vaccine status, then you will continue to wear a mask in the workplace. This really goes to whether you want to have a nationwide policy or a localized policy, because we still do have some locations where face masks continue to be required in the workplace. So again, is sort of balancing, do we want simplicity, one policy, or are we willing to tailor our policies? Because I think candidly, what we're seeing is that a lot of employees who are vaccinated are more eager to get into the workplace if they know that they don't have to wear a mask all day. It really, the mask piece of it is deterring some from coming back. And a lot of them, our clients are keeping that in mind as they're crafting their own policies. So one other note I think that's important in terms of mask wearing and should it be required or should it not be required? The CDC guidance certainly allows for employers to maintain mask mandates in their workplace. It expressly says that you need to continue to follow your employer's policy. But there's still localities where you do in fact need to wear a mask in the workplace or it's recommended. And that can become really important because some of these state laws provide shields to employers who comply with the local health department and CDC guidance. So they'll say you're immune from certain types of claims by employees if you've maintain these types of policies. So if you're in one of those jurisdictions, I'm just flagging it to keep it in the back of your mind that you may want to err on the side of being a little bit conservative with the mask policy in order to avail yourself to those immunity protections that do exist in certain jurisdictions. All right, any questions before we jump to the topics a little bit to the latest from DC on non-competes?
I think there is one question in the chat, going back to, I think, slide 30. It's a question about resources. Are there any resources for local employers to use as sample correspondence?
I'm not sure locally what might be out there. We can certainly check and circle back if they're in an Autumn, you may know off the top of your head if we have any publications that are already out there on this topic as well.
We have, I do know we have a couple of blog posts on our employer blog, the employer report. And so I do know that I think there may be two that go through this and just provide a little more specified information in print. But that's all I can think of. Actually, let me take one step back. There's also a video chat on our video chat series, the Employer Rapport, and we can circle back with this information that discusses proof of vaccination as well. So I think both of those kind of resources will be helpful, and we'll be happy to circle back with those.
Great. And I think we just actually had two more questions pop up. One around what are DC's guidelines on masks in the workplace. So DC has followed the CDC guidance, meaning that those who are vaccinated may go maskless. Those who are unvaccinated should continue to wear masks. And Another question, thoughts about employees who do not want to allow unvaccinated colleagues into their private offices. So this continues to be a pretty significant challenge in terms of how to manage those who are vaccinated versus those who are not. We have some clients that have implemented badge systems. It's something that we've largely stayed away from or recommended because it just creates a separate dynamic that can be difficult to manage. But there are certainly guidance out there and guidelines that you can establish as an employer that says, no meetings in private offices if you can't maintain social distancing of X feet, or we shouldn't, if we have unvaccinated and vaccinated individuals meeting, it should be in a conference room of a certain size. Some employers are establishing vaccinated, unvaccinated areas. So, the 21st floor is for those who are vaccinated, the 22nd is for those who are not, in order to manage this type of issue. So it's delicate because obviously there's a human dynamic and discomfort from those who are vaccinated. Also just a feeling of potential exclusion from those who are not vaccinated. But it really, I think, is there's a fair amount of flexibility in terms of what the employer can do in thinking about, do we have policies around what we do with vaccinated versus unvaccinated in terms of where they can meet, the size of the room, those sorts of issues, to help provide comfort to those who are vaccinated, but also to make sure that those who are not are able to feel included in meetings and not being excluded, particularly if there is a disability or if there is some sort of religious accommodation issue. The other thing that we've seen also is that there have been some clients who say you need to have proof of a positive test within the last 2 to 3 days to be in the office, which also can help manage those who are vaccinated but concerned about those who are not. All right.
Also, follow up with the group to share the mayor's order, what that includes details about the mask mandate and how employers can have their policies to comply with that.
All right, with that, we'll move on to our last topic, which is about changes with simultaneous and post-employment restrictions in DC. So here I will just be taking you through the new ban on non-compete agreements in DC, as well as a bill aiming to clarify those restrictions and taking you through what employers should be considering in light of this new ban. So essentially on January 11, 2021, the mayor of DC passed a ban on non-compete agreements. And it really is one of the strictest bans on non-competes in the US. It's very similar to bans in Montana or California in that it is a blanket ban on non-competes, but it actually goes a little further in that it makes non-competes void, not only post-termination, which is what we typically see, but also during employment. And it also requires employers to provide notice of the non-compete ban to its employees. So the bill prohibits employers from passing agreements or policies that restrict employment during or after employment by another person or operating their own business. And it applies to all DC employers with the exception of the city and the United States government. And it applies to most employees working in DC. It defines employees as any individual who performs work in DC for a DC employer or any prospective employee who one would reasonably expect will be providing their services in DC. It does exclude paid volunteers, babysitters, medical specialists, which it defines as physicians who have completed residency with a total compensation of $250,001. So the bill is kind of twofold. So it does not apply to non-compete provisions and agreements that were entered into prior to the act's effective date. but it does apply retroactively to workplace policies. So as a result, all workplace policies that prohibit an employee from being employed either during or after employment by another person or operating their own business are now invalid. That said, it does not apply to confidentiality agreements. The bill clearly states that it does not prohibit otherwise lawful policies that prohibit an employee from disclosing an employer's confidential information, proprietary information, trade secrets, customer lists. And it's silent with respect to non-solicit agreements, but in a report that was passed late last year, a DC councilman did state that there was a difference between non-competes and non-solicits. So we presume that it does not apply to non-solicits. The other thing that the Act does that's a bit different from other non-competes is it does require employers to provide written notice. And just the language in red, which you can see, is really the notice that you want to be providing to your employees. Essentially, no employer operating in the district may request or require any employee working in the district to agree to a non-compete policy or agreement with the ban on non-compete. And this notice must be given 90 days after the Act becomes effective, which we expect will be in the fall. 7 days after an individual becomes an employee, and 14 calendar days after an employee requests written notice from the employee of the, if the employer receives written requests from an employee for the notice. And one thing to keep in mind is that all DC employers need to provide this notice, whether or not it uses non-compete agreements. I see a question just popped in. So employee is defined as one who's employed directly by an employer, so it does not apply to 1099 contractors. Employers may face liability for using non-compete provisions. So the consequences would be twofold. There's both a civil right of action and an administrative complaint procedure. Statutory remedies will range from $500 to $3,000 per violation. In addition, the mayor can assess an administrative penalty of no less than $350 and no more than $1,000. And before implementing that administrative penalty, the mayor will need to provide employee notice of the violation, the amount of the penalty, and an opportunity to request hearing pursuant to the APA. And the Act is silent with respect to attorney's fees. So in light of the confusion really with respect to the non-compete ban, primarily that it does not permit employers to address any situations where there would be a conflict of interest during employment, and then it also does not permit employers to implement reasonable post-termination policies. Another clarifying legislation has been proposed this year. And what it aims to do is clarify that conflicts of interest in the workplace would not violate the district's ban on the use of non-competes. And it also aims to clarify that employers may bar employees' use of sensitive information, both during and after employment. The bill is now pending before the DC Council and has been referred to the Committee on Labor and Workforce Development as of June 1st. One thing to note is that even if the bill does pass, it would not resolve all the concerns around the ban. For instance, it would not provide the employer ability to protect itself against employees accessing confidential or sensitive information, and then working at the same time or subsequently for a competing business. So in light of these updates, what DC employers should aim to do is review their employee handbooks, their policies, their form offer letters, and make sure that they don't include non-compete provisions or language that requires exclusive employment that would violate the act. And then you want to make sure that you're training your managers and HR on both the prohibitions, but also on realizing that they need to provide notice, even if you don't have any non-compete language in your policies or handbooks. You also want to make sure that they know that the non-compete ban applies both during and after employment. And that's probably something that's very important to flag, because most other non-competes in the US only apply post-termination. And then making sure that they know that non-solicit agreements and confidentiality agreements are still valid. So, as much as possible, still making sure that you have those steps in place to protect the company's confidential agreement. And then the last thing that you want to do is think through what the best ways for providing notice for your covered employees will be once the bill is effective, and updating your onboarding material, whether it's your intranet sites, whether it's a onboarding email or just a paper notice that goes out to your new employees within 7 days of hire.
Any questions for Adiola? And while we wait for questions, I do want to kind of like, I saw a hand raised. I do want to kind of like give the group kind of a overview of like the next steps. As was shared, this ban on non-compete is not yet applicable, though it has been passed, and it still needs to be fully funded in the budget, and the government still needs resources and FTEs to enforce the language. So the earliest that it will be applicable is October 1 of this year. And we understand from talking to the Committee on Labor and Workforce that is the plan of the committee to try to find additional funds to make this law applicable this year. So in addition to that, what the chamber has done since the law was enacted, we've submitted comments on testimony. We've raised these concerns that you've heard to the council, which has resulted in at least one amending clarifying bill that's still pending. But we do know, as Adiola said, it doesn't address all of our concerns, particularly around simultaneous employment. So we are seeking some further amendments from the council to clarify and carve that out so that employers have the flexibility to say, hey, you're working for me now currently. It's probably against law or against our contracts with our partners, business practice for you to simultaneously be working for the employer on the exact same simultaneous exclusions. We are still seeking additional changes to, so hopefully we get that done before October. And then we would like to see some further changes on the post-employment side, but we wanted to make sure this group is aware that this is something trending and just be prepared for some kind of law by this fall. Any questions?
Well, Erica, if there aren't any questions, I do want to thank Krissy, Dee, and Autumn for a wonderful presentation. I'm excited about this presentation, and I want to extend the invitation for you all to come back and come back soon. Having this be a CLE event is an enhancement to our EAP presentation and program for this quarter's seminar. And really want you guys to come back. You've done an amazing job, and I hope everyone out there listening has been enriched by this presentation. And as we noticed with 2020 effects, we have this opportunity in 2021 going forward to revisit how we are in the workplace, have a great opportunity to make it better for employees and employers. And as the EAP and the DC Chamber of Commerce, we want to make sure that we have a more fruitful environment for both the employer and the employees. And I think presentations like this help us get to that goal or that end. And we'll keep doing this good work to help employers make a workplace better for their employees. So if you have any questions for the EAP or want the EAP to step in and help you with any of your matters, we're here. I put my contact information into the chat. That's Ryan at rljoneslaw.com. And you can see that there. We'll address any other questions on the back end. And I'm not sure, but Krissy, are you going to make this presentation available to revisit?
I believe it is something that's recorded and will be circulated, but Erica, check me on that if I'm not correct.
Yes, we are recording. We will circulate it, and we will provide you with the details, as well as we would love to share this group your contact information. So if they have questions, they would like to engage it with you specifically for any issues that they have coming up, for any additional counsel, we would love to share your contact as well.
And as a matter of course, please fill out. We're going to send out a questionnaire about how we did today. Please provide us feedback. It helps us get better. I think that's important for the program and our presenters, so that they know that they've done a great job or a decent job, and how we can get better if we need to get better. So please provide that feedback to us. It's critical to our mission. And Erica, if is there any more we need to say?
No, we appreciate everyone for joining us this afternoon. Again, thank you to our three wonderful presenters, Baker and McKenzie. You've been a wonderful partner and member of the chamber, so we appreciate your support today. Thank you, Ryan, for leading our EAP council. So if there's anything else, please let us know. We'll follow up with additional materials and information.
Thank you very much. Appreciate everybody's time.
Thank you, everyone.
Have a great week.
Thank you.
You too.